Jaime, welcome to Importer Insight. Thank you so much. Could you tell everybody about yourself a little bit?
Sure. So my name is Jaime Bustamante. I'm the Vice President of Trading Assistance and Business Development for the DRC. I've been working for the DRC for 25 years, actually, and I started with the DRC back in 2002 when they opened the DRC branch in Mexico. And this
Nice.
Mexico office started to promote the DRC services in Mexico, Central, South America. And because it was the only office that spoke Spanish, I was kind of in charge of all the Latin American countries and trying to bring awareness of what the DRC was and what services it provided and how can we help parties prevent and resolve disputes and so on and so forth. And in 2005, the DRC decided to consolidate all the services from Ottawa. So we also had an office in Chicago at the same time that it was open, the office in Mexico. We closed those ones and started working and offering our services directly from the headquarters in Ottawa, Ottawa, Ontario, Canada. That's where we are. And since then, I started as a manager of trading assistance and then moved to director and then moved to vice president. And that's where I am right now.
That's amazing. I saw that on your LinkedIn profile that you've worked there for 25 years. You've seen the entire evolution of the DRC because they only really started in the 90s, right? Am I correct about that?
1999. That's when. So the creation of the DRC it's very interesting because with the NAFTA. Back in 1994, NAFTA offered a mechanism under their Article 707 back then, for the possibility of creating a dispute resolution mechanism to be able to resolve disputes between private companies without the need to get in the governments involved. And it took a few years before it actually got tracked that the North American companies in the produce industry needed something that can work not only domestically like PACA or PACA would work in the US, or how the Canadian Food Inspection licensing and arbitration system had only worked in Canada. So they wanted something that could work tri-nationally. And after several meetings, conferences, reunions between industry, government, and consultants, the DRC was created in 1999 to be able to provide the services for all three countries. And like you said, this has evolved, right? This is no longer just a North American thing. We do dispute resolution everywhere in the world. So the first edition, after the North American countries only being able to resolve disputes between Mexico, United States, and Canada, was allowing commercial partners of companies located in Mexico, United States, and Canada to be able to file disputes and be members of the DRC at the same time. Then we added transportation companies to offer a similar service that the Blue Book was offering back then, but PACA was not offering. So we kind of took from everyone, CFIA, PACA, Blue Book, and everything, and created this DRC to be able to have this tool that everyone in the produce industry can use. And then after that, we opened the membership to companies to exclude the limitation that we had that produce needed to enter into commerce in North America. So back then, before we took this limitation off, we could only resolve disputes when the product entered commerce in Mexico, United States, and Canada. So all the offshore shippers could have access to the DRC. But if someone from Chile had a dispute with a European country or European company, they wouldn't be able to use the DRC. So that was removed back in 2020, in June 2024. And now all DRC members, regardless of their location, they can actually use our services for preventing dispute and resolving disputes through our system of dispute resolution.
Yeah, that's amazing. You know, I've been on the import side for almost 20 years. And, I discovered the DRC maybe like 12 years ago or so. My father and his partner, I was working for them and we were looking to expand, and I wanted to expand into Canada. And so, because I felt like that's where the opportunity was. And looking into it, I discovered the DRC and found that we needed to become members in order to protect ourselves, which, most importers on my side, or at least in the US, and this was, I think, the feeling, 15 years ago, 20 years ago was you didn't want to do business in Canada because they didn't follow the same rules as the US, but you really help with that. And I was intrigued to learn that you actually represented Mexican companies as well. I didn't know that. I thought that you only represented really US companies with Canadian companies and vice versa.
That's one of the misconceptions that actually everyone has about the DRC, that we only help companies who ship product to Canada, whether they're normally in the US. Like US companies have this reference from PACA that goes over 100 years ago, when it was created. So it's really easy for US companies to understand how this system works and why it's necessary to have a similar system in Canada. And that's the DRC for them.
Yeah.
But even right now, US companies who ship product to Asia, to Europe, South America, or even Mexico, they can actually use the DRC services because they're not covered by PACA on their exports. They're only covered by the PACA domestically when the product enters into commerce in the US and stays in the US. So yeah. And it took a while, but companies started understanding that mechanisms like this, while they do not exist anywhere else in the world, they can be used.
Right.
Now, there are similar tools that exist in Europe, but it's a mechanism that is voluntary. It's not mandatory for anyone to use. And in all honesty, after having discussions with them in the past few years to see how we could have collaborated with them to,
make it mandatory.
Yeah. Or if they're not having success by companies using their system, okay, let's use a system that is having success, such as the DRC. And yeah, it's still an uphill battle there to make them understand how this could work. But we're trying. We're doing our best.
Yeah, I didn't realize that it's mandatory for Canadian companies. Correct me if I'm wrong, but it's mandatory for Canadian companies to be a member or in good standing with the DRC in order to operate in the fresh produce.
That is correct. It's a similar...
Which I didn't know, and actually makes me really excited to sign up because now I know I'll be protected if there is an issue, which I didn't feel like I had that protection before.
And you mentioned something really important here when you were giving me your experience with the Canadian market that 20 years ago, 25 years ago, or 15 years ago even, the Canadian market was seen as a complicated market. Let's put it that way.
The Wild West, the Wild North.
I think bringing the DRC into effect in Canada has lowered that risk of having a dispute. Like, we're in an industry where disputes are normal every day because of the perishable nature of the product every day. So, but having a third party like us intervene in that dispute resolution process can bring a lot of value to the actual relationship between companies. Okay, you're looking to a third party. We're not representing one or the other. We're looking at from a impartial perspective, trying to help understand both parties, where the mistakes were made or where the responsibility lies, through rules and regulations that apply by default to transactions when the contract between the parties or the terms between the parties are silent or have not been discussed. Or, and this is another funny part, the North American trade or market has its own terms and definitions and concepts compared to what is used outside in the rest of the world.
Right.
Sometimes people think that they're dealing with the same terms, and you look at what exactly the expectation was between the parties, and it was completely different because even though they use the same term, they mean different things for each party. So that's where the DRC rules come into play because they are defined there. So it's easier to, use as reference something that is in writing, which is our trading standards, transportation standards, good arrival guidelines, good inspection guidelines, all these tools that we have or guidelines as reference when you're doing business in our industry. So
yes. So tell me, what have been the biggest mistakes that you see importers make that they could have, solved had they talked to you prior? Or what disputes have you seen that are like the craziest disputes you've had to mitigate throughout your years?
Well, there's all ranges of disputes from, a $700 claim based on principle because, the the shipper believes that there was no need to the other party to make an adjustment or deduct that amount or whatever, and it goes through the arbitration process. And I mean, we have a process where we do consultations, then an informal mediation process, and all that's covered by our membership. It doesn't have any cost to the parties who are members of the DRC.
Right.
But even when we say, look, okay, principle is an important thing, but, maybe it's better to just settle it, splitting the baby, like is normally said in the industry, 50-50, or I don't know, accept less just to avoid having to go through the process. Now, if you go through our arbitration process for small claims, it's very accessible in terms of amounts that you have to pay in order to initiate the claim. And if you win, you recover that administrative fee that you pay. But yeah, that's like the ones that are on principle are the ones that, to be honest with you, are the ones that you say, oh, I wish they would have, just listen a little bit more.
Yeah. There's a lot of big egos in our industry.
Yeah.
And
then there's the ones that, forgetting that on FOB shipments, FOB terms, when they're used, the shippers lose ownership of the product as soon as the product is picked up by the receiver's truck. And the receiver has the right to reject or not reject the load. And if they're not rejected and they unload that truck, they have committed an act of acceptance. And therefore, that product can no longer be rejected. The receiver has a right to claim damages, but is not obligated to give the product back to the shipper. But that turns into a whole other series of issues, in regards to that dispute. In the US and Canada, we have inspection services provided by the government, the USDA, the US and CFIA in Canada. So forgetting that those are the primary services that DRC members must use, unless there's an agreement to use something else, that's something important that sometimes is forgotten. Yeah, I would say that there's nothing memorable about disputes, to be honest with you. There's nothing to resolve or like to make big, because the last thing you want when we receive a dispute is to actually let it go to arbitration. You want to be able to resolve it during the consultation part or the informal mediation. And I do see it as a failure when I'm not able to get the parties to settle the dispute amicably. But we have a very good successful rate in resolving disputes. 80% of the disputes that we receive are resolved in the consultation or informal mediation process. Only 20% go to arbitration. So I think we're doing a pretty good job educating the Canadian market, the US market, and hopefully the rest of the markets out there at this point who want to use us to resolve disputes and understand that the market better.
Yes, no, for sure. You focused on the Mexican market when you started in this industry.
Yes.
How has that changed? What kind of disputes do you resolve there? Can you tell me a little bit more about your focus?
It's a similar situation. Like the disputes normally are the same. One thing that I see from Mexican shippers that they don't grasp the idea on these terms that are used. So FOB, CIF, CFR, all of these Incoterms that are used that starts with an F or a C for DRC purposes or international purposes. Okay, you're putting your product from the farm to the border, whether it's McAllen, whether it's Nogales, whether it's Laredo, whatever it is.
Right.
And they believe that their responsibility for them ends when that truck comes and picks that load up. The responsibility of transit, that risk transit ends for them. But if they know that their product is going to a receiver in New York or in Toronto or in Vancouver or anywhere else in the north of the US, they're still responsible for the quality and condition of the product to the final destination, as long as the receiver is able to prove to you that transit times and temperatures were maintained accordingly during that period of transit. So I mean, that's one of the things that I believe needs to be reinforced into the Mexican market. Now, there are terms there, restrictive terms that can be used if you don't want to be responsible for the rest of the trip of that product. And those are defined in our trading standards. And it's a matter of, reading or discussing it with us, and we can help you with that. Mind you, receivers may not be so keen on accepting those restrictive terms.
No.
So they don't want all the risk on the transactions, right?
Yes.
Another thing that I think is very important from the US side or Canadian side, when they are investing in farms or crops in Mexico, using the DRC as a tool when they're putting money in advance as a way to be, protected, because, well, it happens. Sometimes they send money and Mexican shippers, growers, either they are not able to make the commitment on that crop, or decide not to, or use the money for something else.
Right.
Then how does this US companies or Canadian companies are able to recover this money? If they don't have a mechanism through the DRC, like the DRC, they will have to use the courts in Mexico.
Yes.
Good luck with the amount of time that's going to take for you to get your money, if you get your money.
Yeah.
So, I mean, it works both ways. The same thing can be applied to Mexican shippers. Mexican shippers can say, you know what? I know this receiver in the US or this receiver in Canada is a DRC member. So instead of asking him for an advancement on payment of that invoice, let's say 50% or 20%, whatever it is, I trust them because I know they're members of the DRC. I've done my due diligence. I checked with DRC, with the Blue Book, with PACA. They look like a good company. Well, I can extend them the credit, and I have a recourse to go after them. And by doing the due diligence, I find that company is financially stable, there's no way they're going to avoid not paying me if there's an issue. So
no, that's very helpful for anyone wanting to export or import anywhere across the world. So you now have opened it up globally. How many countries do you represent currently? And have you settled disputes outside of Canada, US, Mexico?
Yes. So we don't have that many yet. I believe it's 93 companies, which are distributed mostly in Central America, countries in Central America, South America, Europe, Northern Africa, Asia. We have a couple. So we're kind of spreading, but normally the disputes that we've been able to help resolve with companies offshore is when they are shipping product either to the US or Canada.
Okay.
Not necessarily outside between them yet. I think the way the DRC will help that happen for companies to resolve disputes that are not dealing in the North American market is by including an arbitration clause in their contracts, where they can say, if there's a dispute, then the mechanism that they will be using to resolve the dispute will be the DRC instead of the courts. That's the kind of promotion we're doing right now for companies offshore. But yeah, we hope it picks up at some point.
I'm sure it will, as everyone wants to come to the North American market, and it continues to grow. So you mentioned you offer education for your members. What are some of the resources that you use for your customers, or what is available for your customer base that people may not take advantage of that they probably should?
So I mentioned it, but I wasn't specific enough. So the DRC originally was sold as the dispute resolution mechanism internationally that you can use. But if you take a further look at, or more in-depth look at what the DRC is a trade standards body.
Okay.
So we have, like I mentioned to you before, the bylaws and operating rules, which establish the rights and responsibilities of members, how to obtain a membership, how to maintain a membership, and the compliance desk, which the compliance desk is the one that if someone reports a company that is not abiding by our general rules of conduct, they can face disciplinary actions, whether there is a dispute or not. So that's an important part, similar to what PACA has. Now, aside from the bylaws and then you could, aside from the bylaws, which establish the membership rights and responsibilities, then you have the trading standards, the transportation standards, the good arrival guidelines, which are all this set of rules and regulations that apply by default to transactions between members. And understanding and knowing where to look for terms, to look for ways to act when you have a situation in a dispute, you'll find all of that in our rules and regulations. Understanding that by being part of the DRC and being part of these trade standards, what you're actually joining is a good players club, where everyone knows what their rights and responsibilities are, And you can contract outside of those rules and responsibilities by having a written contract or whatever it is that you have in order to establish a contract at this point, because it can be text messages, emails, or something else.
Mm-hmm.
But where that contract is silent, then our rules enter to play as the default rules. And the more you know about that, I think the easier it will be for the salesman or the buyers from a company to avoid a dispute. So we do offer in-house seminars to our members. Seminars, if a company wants us to meet, travel, and go to their company and have a seminar for a day where we discuss issues, we discuss terms, we discuss everything there is in our industry, we do that for them. And it's part of the services that we provide to our members. And no, it's extra cost. And education allows and is a big part of preventing disputes. So part of the prevention of disputes is the education part, but it's also the service of consultation that we have.
Mm-hmm.
Our consultation service are private and confidential calls, emails that you can share with us where you don't really want to open a file. You just want guidance on, I mean, a lot of the people in this industry knows the rules and regulations, and they just want to make sure that they're doing the right thing. A quick call to us or a quick email to us, that will help them either establish their right or wrong and know how to negotiate a settlement with their client. So, and it works both ways, right? Sometimes the receiver calls us, hey, Jaime, I received this load and is warm. It arrived warm with hot temperatures, hot pulp temperatures. I'm requesting a government inspection right now. Is that all I need? Well, no, there's more to it. You also need to request a temperature inspection. You need to make sure that hopefully the defects associated with the inspection report are connected to the bad temperatures in transit, etc. So having all that knowledge and just by a simple call, it can save you a lot of trouble. Now, we also have checklists for buyers, sellers, distributors, wholesalers, retailers, transportation companies, carriers, where they can just go, I did this, I'm following this spec or this SOP. You can use SOPs, standard operation procedures in your company, and just use them as checklists. Yeah, I did this, and I'm following up on this, and that. And actually, these checklists have been used by the Fresh Produce Transportation Industry Task that IFPA offers on their website, and they're there, and so yeah, no, it's a big part of what we do. Another part, which I think is also very important, we do review contracts, marketing agreements, consignment agreements for buyers and sellers to try to make them more equitable for the parties and not just one-sided, or help them understand really what entitles using a term like consignment or a market agreement where certain things may or may not apply and you should be aware of it. So we do that, and it's part of the services. We don't charge for it. So yeah.
I think that's a really great benefit to being a member, especially as the older generation that has represented this industry for so long. They're kind of moving on now, and there's new blood coming in. And how do you get them prepared quickly? You could use tools like what you're offering to give them like a baseline so that they know and can operate easily. And I think you touched on something like it's a good players club, because there's so much fraud, spam, and people trying to take advantage of just everyday companies in the produce industry. So you're right. Like if they're on the list, they're good, and if they're not, well, it's questionable.
The risk is higher. I'm not saying that because they're bad players. I'm just saying the risk is higher.
You're right. No, totally. Yeah, the risk is higher, and with importers, I mean, you're taking on so much risk, so much money is at stake, and it's just really important to have all your I's dotted, your T's crossed, and I think you guys can really help with that. I really do want to know what's the most memorable dispute you've ever been part of. Do you want to give a little bit into that, or?
Well, I mean, I'll talk about a recent one that I think is very important, and it can touch on every aspect of a commercial relationship. Recently, we had a dispute, and actually, I wrote an article about it for our Solutions newsletter. We have a Solutions newsletter. That's another resources that we have for our members, and actually for everyone. It's open on our website. Anyone can access our Solutions newsletter, and we have articles there and everything. and other information. But this one is memorable, not just because it's recent and it comes to my mind real quick, but it's something that a lot of us don't think in the industry. Sometimes we go by the name of the company as we heard it or as they sent it to us, and we don't really pay attention to the full legal entity name of that company. And you think you're dealing with one company when in reality, you're dealing either with a sister company or a company that follows the umbrella of a corporation, but it's a separate legal entity. And for DRC dispute resolution rights, one thing that is important to understand is that when you join the DRC, what you're actually signing is a arbitration agreement that says that any dispute that you have with another member must be resolved through the DRC dispute resolution system and rules. So I had this case where during the consultation part and the informal mediation part, this shipper had a contract under one name, the payment of the proceeds of that consigned load were going to come to a different company. And one of those two companies was a member of the DRC, but the other wasn't. And unfortunately for them, the receiver did not accept the fact that they were dealing with the DRC member. So they challenged the claim. So it took an arbitrator, even through the informal mediation. And we told them, look, this is, it's going to be a hard sell to convince an arbitrator that you have rights under the DRC because the contract is signed with a company that is not a member of the DRC. So contractually, you don't have that right, and membership rights are not transferable. That's why when you sign an application to be a member of the DRC, the company that signs, a legal entity that signs, is the only one that is covered. And our rules don't provide for assignment of rights of arbitration or for membership rights to be transferable. And so unfortunately for the shipper in this case, the arbitrator decided against them, dismissed their claim, and it was not able to be resolved through the DRC. That's memorable because that talks about doing your due diligence.
Yes.
Keep your records updated with the industry and the associations and whoever you're listed at and pay for a membership or something like that. Make sure your records are updated so that you're covered. And there's a difference between a ABC Company LLC and ABC Company Inc. and ABC Company Ltd.
Right.
No,
that's a very important lesson. And thank you for sharing that. I think people, watching this will definitely remember and take that into consideration when they're doing business, hopefully in the future. I hadn't thought about that either, but you're right. And
it's not uncommon. It's not uncommon in our industry to see several companies with similar names. Some are sister companies and some ones are completely not related at all. And you think you're dealing with one of those, and just make sure
you're
are.
Not. Yeah. Yeah, no, that's a great lesson. Thank you for sharing that. And I appreciate you diving a little bit deeper into your most memorable dispute. So what are kind of like the biggest warning signs that a business relationship is kind of falling by the wayside? What do you think your members and people watching this should look out for?
Well, the first one I think would be there's a slow pay situation. When a company starts slowing on payments, that they're not meeting your payment terms, they're not paying within 10 days or 21 days, or they exceed a lot your payment terms, they may or may not having financial difficulties. So when that's happening, that should raise a flag of contacting DRC, PACA, or the Blue Book, just to see if you are the only one experiencing that issue with that company. Because the likelihood that company is having financial difficulties is if you see claims appearing everywhere. So protect yourself in that way. Make sure, you are on top of those low pay situations, And again, I always emphasize on doing your due diligence. Just if someone approaches you as a first time customer and they want to establish a long-term relationship with you, don't be afraid to contact the DRC. Don't be afraid to contact PACA, the Blue Book. You may or may not have access to the Blue Book. That's That's another tool that is out there that everyone should be using too. There's other companies, you pay for it, right? But they give you credit history of these companies. Like nothing is better than an ounce of prevention. That will save you a lot of money in the future. So the more you know about your client, the better it would be for you. And also, if you decide to establish a commercial relationship with that client, under what terms? Because you at that point are the one that, as a shipper, you need to decide under what terms you're going to work with that company, because you're the one at risk of not getting paid, because everything in our industry is as a credit, nothing. Yes. So that's a lot of risk as a shipper. So
yeah, knowing terms is so important, and it's always should be part of the initial conversation when you're talking with anyone. What I mentioned that terms are different in North America versus around the globe. Like what are a couple of things that stand out to you that are the major differences that people should keep an eye out for?
So I mentioned the Incoterms, right? And the Incoterms, for example, the most used in North America, especially between the US and Canada, are FOB and deliver. But if you look into the Incoterms, the only one that is defined, and the Incoterms are the International Chamber of Commerce, International Commerce terms that are defined to help the industry have a set of logistic rules that apply to transactions.
Thanks for clarifying that.
Yeah. So North America the US and Canada have modified these terms. And FOB, for example, should not be able to be used in land transportation. It should only be used in maritime transportation.
Really?
But here we use the terms FOB and then FOB at deliver price, which is an addition, which is something that doesn't exist under the Incoterms, but you're bringing the term deliver. And the deliver term doesn't exist in the ICC, International Chamber of Commerce, but there are deliver at place, deliver duty free, deliver at different destination. But those are specific things that need to be followed, terms that have to be followed. And so, for example, if you ask a European company or a shipper from South America, hey, I want you to send me this load of blueberries and deliver them to me. If I'm an American saying those terms, I am assuming that the risk of transit is always going to be on the shipper, because delivered terms put the risk of transit on the shipper.
Right.
But for a shipper in South America or Europe or somewhere else, if I look at the Incoterms, I'm going to say, oh, I can deliver that load as covering the cost of freight, insurance, and anything else, but I'm using, any F term or any C term that starts with those letters, and I'm fulfilling the part that I'm delivering the product to you, but I never switch the risk of transit to me as a shipper. The risk of transit is passed. So a receiver receives this load, and they're thinking, oh, it's a transportation claim. Shipper should handle that. Not according to the Incoterm, because shippers in the US and in South America and Europe, South Africa, anywhere else in the world, they're using the right terminology and specifically. So again, the thing is, what we're not discussing here is the risk of transit. It's lost in translation when you're using Incoterms in North America or South America. So let's go back to the FOB deliver price. Okay. All I'm saying is that I'm paying for the freight and I'm adding it to the invoice, but you're still responsible for any risk of transit, for any transportation issue, whether it's delay in transit or transit temperatures go wrong, the cold chain is lost, whatever. That doesn't exist anywhere else. It's just in North America. So those are little things.
Has there been any push from your side to kind of make it an even playing field or use the terms correctly?
Well, through disputes we have been trying to educate companies to use the right terms or negotiate using the right terms. But sometimes companies do pay attention to it, and other times we see it repeatedly that they just go back to their ways. And that has to do with training your buyers and sellers, right? To have that discussion specifically, to be specific about it. Like another thing that I see constantly is that the definition of a consignment transaction or an open price or price after sale or claiming damages or reworking a load or regrading a load, all these are different terms that don't mean the same. and you cannot use them intercombined one or another. Either you pick one or the other. And there's definitions for each that apply. So that also gets sometimes lost when you use loose terms like I will hold your hand, I'll help you with this. That doesn't mean anything. So
Okay.
use terms that are actually defined. And that's a good part about the DRC,
Right.
PACA, and the Blue Book. They have them defined. So use them as defined already by these associations.
Yeah, no, that definitely helps, especially when everything is going to be looked at in the end, if there's any situation. I was curious, you see a lot more sales happening by air. Have you had to settle any disputes that are, transported by air versus ground or maritime?
No, air freight and maritime freight is complicated to be involved in resolving the disputes because these maritime transportation companies, these air freight companies, they have their own methodology to make a claim and you must follow it.
Mm-hmm.
Otherwise, you've lost your right to make a claim against them. And if you better make sure you read that small print on the back of those airway bills or maritime air bills, because there's a lot of information there that literally absolves the freight company, the air freight company or the maritime company from any fault on anything that happens in transit,
Hmm.
except obviously a specific malfunction of
Right.
but delays, port delays, and all of that, it's the risk of transit. Who has the
Yes.
risk of transit is responsible for that, not
Yeah.
them. So
Hmm. Well, thank you. I wondered about that. I've had people in the past reach out to me from, the Middle East asking for avocados, mangoes, and so forth. And I was curious if you had seen any kind of disputes there. I'm always wary of, who you're working with. And go ahead. You're going to say
I've
something.
heard about those. I've
Yeah.
heard about the difficulty on collecting sometimes on those shipments to the Middle East, and
Oh yeah, no, it's you pay before it goes out the door. That's what
yeah,
it's, or you're not getting it
yeah.
basically. So let's see. So I guess you've been in this for 25 years. What's the biggest change that you've seen in your time working with other companies, settling disputes, and so
Yeah.
forth?
So, not looking at from a buyer and seller perspective or packaging or anything like that, because that
Mm-hmm.
has evolved over the past 25
Right.
years. How things are grown, how the varieties that have come out of different
Mm-hmm.
commodities and stuff like that. I try not to get involved in that. That's not my field.
Right.
But looking at from a dispute resolution point of view, of if you're making a statement, you better have the supporting documents to back it up, to back up that statement. So technology has brought a big part in being able to establish contract terms.
Mm-hmm.
By originally it would be everything through a call, then a fax, now
Yes.
then emails, now text messages, and technology has helped us being faster at
Mm-hmm.
communicating things, but has make us be, I believe, a little bit lazy on be efficiently communicate what you want. So now if you look at a text message and compare it to an email, the text message is much shorter. So you're
Right.
losing information there. And then it used to be a fax. You used to like really type everything.
Yeah.
And then the email made it, no, I can just make it faster. So yeah, it has bring that opportunity to be faster and doing a business in establishing a contract. But
The details are lost.
yeah, a lot of the details are lost. And then when you
Mhm.
make an argument where, oh no, we discussed it over the phone, we had a verbal agreement, and did you follow it up with an email saying, hey, following our conversation, this is what was discussed, just confirm that this is what was agreed. The
Yeah,
same with the text message. We're losing that. We're losing that
I can see that.
acknowledgement of terms discussed or agreed to. And I've seen cases where a contract was defined based on exchange of text messages. And I remember the arbitrators contact us for advice on rules, regulations, and all of that. And they were like, I'm not sure I'm going to be able to come to a final decision on this one based on just text messages because they're so loose and they're not connected specifically to a transaction because, yeah, there's communications going back and forward, but I don't know which load they're referring to.
Right.
And so, I mean, in this case, the arbitrator was finally able to come up with a decision and all of that. But technology has brought us a lot of advantages in terms of time, but I think it has made us a little bit lazy in make sure that what you wanted to communicate, your expectations were met through a text message or an email, or just follow up with that.
Yeah, I can agree with you there. I think there's a lot too that can get lost in translation, especially when people's first language isn't necessarily English or whatever language you're communicating in. It's easy for things to get misinterpreted. Coming from like the operator's perspective, we're like moving so fast, and you might have a situation here, but you've got, 10 other situations that you need to handle. And so sometimes things get lost.
Yeah.
But I would agree with you. Definitely text, WhatsApp has made life, fast, but not as detailed as we probably should operate. Yeah, would agree with you on that. So I think you've given us so much to really reflect on. And I wanted to kind of end the conversation with, what's your one piece of advice for importers starting out in the business, other than joining the DRC? But, what piece of advice would you give for a new importer?
So I see and I hear this a lot. No one enters a commercial relationship, whether it's in produce or anything, any other industry, thinking that they're going to have a problem. Everyone enters with great expectations that everything is going to be fine. However, disagreements, contractual disagreements, are the most common thing that happen on an everyday transaction, especially in an industry where we have a commodity that is perishable and it doesn't last that long in the market. So being aware that by having a conversation, don't be afraid to have a conversation about, okay, in the event that we run into this issue, that this happens, because everyone has had experiences. This happened to me the last time. Okay, if this happens between you and me, how should we resolve it? What steps, what process should we follow? And as long as that's discussed, I mean, problems should be discussed. That would be my piece of advice when entering a new business relationship with someone you want to start a long-term business relationship. And the other thing is, if you're dealing outside of your country, if you're exporting, do a little bit of research on what tools that country offers you in terms of tools that you can use to, in this case, like something like the DRC, to prevent a dispute or to have a dispute resolution mechanism, or, what financial assistance you can get, or what factoring companies exist there, or, anything where you have access to that information and those tools, that would be to your greatest advantage so that you don't freak out.
Right.
One of the things that I've heard a lot in our industry, and this coming especially from companies in Mexico, Central and South America, when they ship product to the US and Canada, they will call me and say, Jaime, they don't want to pay my invoice. I mean, they don't want to pay the undisputed amount, because they do have a claim. Let's say they sent a $30,000 invoice product, and there is a claim, and the receiver is offering to pay half of it, $15,000.
Right.
But they will only pay me those $15,000 if I agree to sign a release form where I'm no longer able to, collect more than what they're offering me, when I know, or I think they didn't do a good job on trying to salvage the product, or they're including expenses there on their account of sales that really we didn't discuss, neither agreed to, and that money probably should be added to this amount, but I'm tight on time. If I don't accept this, I may not get my money. Well, but that's why you have these tools. That's what you have the DRC for. You can say, okay, if you don't want to pay me the undisputed amount, don't worry. I'll file a claim through the DRC or through PACA or through the Blue Book for the full amount. And for a receiver who doesn't want to pay the undisputed amount, and they don't pay it through the dispute resolution process, and ends up in a formal complaint, and they lose, and they are awarded, the shipper is awarded interest, the interest would be based on the full amount of the invoice, not the undisputed amount. Those are things that for me, should be discussed.
Yeah, no, great advice, Jaime. And I really appreciate your time here today. I think our importer community can definitely learn from your organization, and we will leave those details about how they can contact you and the DRC in the description. So thanks again for coming on Importer Insight. Did you have a good time?
I did, Amanda. Thank you very much. And I wish all the best to your podcast. And
Thank you.
you get a big audience out of this. That'll be great. And
hopefully so.
If you think there's more to discuss at one point, I'm available for that.
Absolutely. Maybe we can do like a series or something. That'd be fun.
Sounds good to me.
Okay. Nice seeing you again, and take care. Bye. Thanks for tuning in to the latest episode of Importer Insight. Stay tuned because there's more to come. Like, subscribe, follow. I'd love to know what industry insider you're interested in hearing from. Take care.